Hey everybody, hope that you are well. In 1965, the United States Congress passed a monumental civil rights law called the Voting Rights Act. And basically this law was designed to combat the kind of restrictions on voting rights that were very apparent during that time. It was one of the civil rights laws that were designed to go after the kind of segregation type policies that were going on in the South at that time. And so I wanted to talk a little bit about that today, given that this very issue is something that Congress will likely revisit this year. So instead of going through the whole statute, because there's a whole bunch of videos and there's a whole lot of discussion about that, and people pretty much have a very general idea, I want to focus in on the parts that are more controversial and what the subject of the new congressional legislation will be trying to target. So I want to focus in on specifically Section 4B. Section 4B deals with a coverage formula that is designed to activate Section 5. Now, Section 5 of the Voting Rights Act is the section, it's called the preclearance section. And basically what that means is that if there's a state that has engaged or that qualifies for a preclearance, that means any voting laws that they want to change would have to be cleared by the U.S. Department of Justice or the federal district court in Washington, D.C. So that's what preclearance does. It basically puts the federal government over the states before they can enact a voting change, a law to change the way in which their votes work. So let's talk about Section 2B of the 1965 Voting Rights Act. So basically, it is a two-part formula. The first part says that if a state or a political subdivision, which is basically a city, if that state maintains a test or device that is designed to restrict the opportunity to register to vote. So basically what the important keywords there is test or device. And basically what that means is during this time and prior, there were different tests that many southern states specifically had to try and restrict voting. One of those tests were literacy tests. There were poll taxes. You had to have recommendations from other folks in that town before you could go and register to vote. So they were designed to keep people or to place as many impediments to voting as possible. So that was one of the things that was the first part of the formula. The second part of the formula was the director of the census had to determine if 50% of the people in that state that were voting age were actually registered to vote. So we all know about the census. We take the census, and we take the census, and the census tells how many people live in a certain state. So basically that's what the census does. And so in order to see if you qualify, to see if that state, the second part of that formula would be to determine, okay, well, is 50% of the people in this state registered to vote or not, according to the last census that was taken. So that formula had the effect of making many of the southern states qualify under the Voting Rights Act to have to be subject to Section 5, which, as I described earlier, that's the part where you would have to go and have the Department of Justice or the federal or a federal district court to approve any changes to voting laws. So for a long time, people didn't like this, but the statute was renewed over and over and over again with other changes in it. But by the time that you get to just a few years ago, in 2013, the Supreme Court issued a decision, Shelby County v. Holder. And this was a lawsuit from Shelby County, Alabama, which filed suit claiming that the Voting Rights Act, specifically Section 4 and Section 5, were unconstitutional. And they believed that this was so because it took away a lot of the rights of the states. So in a 5-4 decision, Chief Justice John Roberts made this point. The court held that Section 4B exceeded Congress's power to enforce the 14th and 15th Amendments of the Constitution. Their reasoning was that the coverage formula, that's what I just described to you, conflicts with the constitutional principles of federalism and equal sovereignty of the states. So what is John Roberts saying there? Well, the idea of federalism is that there are states have a certain amount of autonomy, and that in Congress' attempt to enforce the 14th and 15th Amendments to the Constitution, they exceeded their constitutional ability to do that. He goes on to say equal sovereignty of the states, because of desperate treatment of the states, is based on a 40-year-old fact having no logical relationship to the present day. So basically he's arguing that the coverage formula that I described to you earlier, the one that says either test or device in restricting votes, restricting opportunity to register to vote, and the 50% of the population needs to be registered to vote. He's saying that those two things are out of date and they don't make any sense to today's situation. So that's basically what he's saying. So the court declared Section 4 unconstitutional, Section 4B unconstitutional. Because of the way the statute is designed, because you could no longer use Section 4B, you could not activate Section 5. So by declaring Section 4B unconstitutional, Section 5 becomes unenforceable, or you can't activate the provisions of it. So last year, the U.S. House of Representatives passed a bill called the Voting Rights Amendments Act. And in it, they designed a new formula that would allow Section 5 to go back into effect. And this is basically what they said. A state and all of its political subdivisions, those are cities, shall be subject to preclearance of voting practice changes for a 10-year period. So they narrowed it to a 10-year period. If 15 or more voting violations occurred in the state during the previous 25 years. So basically, they're looking at a 25-year window and saying that if in that 25-year period you had 10 or more, you had 15 or more violations, that you would be subject to the preclearance. That means for a whole decade, you would have to go and ask the Department of Justice or a federal court if you can make certain voting changes. They go further. Or 10 or more violations occur during a 25 period, and at least one which is committed by the state itself. So if you have subdivisions in that state, you have local governments in that state that are making violations, voting rights violations, and at least one is committed by the state, then you would also be subject to the preclearance rule for a decade. So the natural question becomes, well, what is a voting rights violation? So if we think about what a voting rights violation, it would likely be any governmental action that would restrict a person's ability to go and vote. So what are some examples of that? Well, there's a lot. Voter ID laws, making it more difficult for people to go and cast a vote. Changing polling places, something that's done a lot by local governments. Changing, scrubbing the voter file. So people who were registered to vote, their name being removed from the registered vote list. That is another example of it. Certain states like Florida, where in their state they passed a constitutional amendment to say that a person who was a felon can now vote. Well, their state says, well, you have to pay a fine or pass court fees before you can vote. So that's almost like a poll tax. So that's another way to restrict voting. Lessening the time that a person has to vote early is another way in which voting is restricted. So there are many, many different ways in which all those things could potentially qualify as voting restrictions or voting rights violations. So you can see that the proposed new formula, is much broader than the one in the 1965 statute. And that's the whole point here, is that the old formula is old and doesn't make a whole lot of sense. But the new formula is much broader and would make it much more difficult for states to restrict voting. And they could find themselves, if this becomes law, it would make it more difficult for states to explain any kind of restrictions that they want. And even before they had a chance to do that, there are many states who have who would automatically meet these requirements, because it's written retrospectively, is written to look at the past 25 years. Many states could find that they could be subject to federal oversight of their voting procedures for a decade under this language. And that's the effect that it would have. So just something that I wanted to make you aware of. This is one of the laws that is really being pushed this year. And it'll be interesting to see if Congress takes this up and if it makes it to the president's desk. So thank you for joining me for this information. I'll be back with another video very soon to talk about another public policy subject. Thank you.